Test 1, 2. Test. Yeah, YouTube. Okay. I hereby call the Police Oversight Commission meeting to order on Thursday, January 14th, 2025 at 5:06 PM. Madam Secretary, please conduct roll call.
Commissioner Goronsky? Commissioner Mejia?
Here.
Commissioner Perea? Commissioner Said?
Here, thank you.
Commissioner Vega?
Here.
Vice Chair Castillo-Lofton?
Here.
And Chair Carpenter?
Here.
And I'm here.
Chair, you have a quorum.
Okay, next item of business. If we could do the Pledge of Allegiance, if you all please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All righty, now it is time for a public comment. This is a time for the commission to receive comments from the public. We will not accept any additional requests for speaker cards once we begin the public comment sessions. If you have not already, please submit your request to the recording secretary. Speakers will have 3 minutes to speak. Madam Secretary, do we have any public speakers?
We do. We have 5 in-person speakers. The first person is Abraham Q.
Thank you.
Good evening, Commissioners. My name is Abraham. I live in Ward 3. I'm also a member of Community Service Organization Orange County. We're here to continue demanding justice for Noe Rodriguez, and to that end, we want to talk about the officer who was one of the officers who was involved with the shooting, Luis Casillas. Luis Casillas not only killed Noe Rodriguez on December 1st, 2024, just a month later, on January 1st, 2025, he shot and killed another man in our community, Henry Gonzalez Jr. Despite Casillas being under an active Department of Justice investigation for killing an unarmed man, he is allowed to continue to patrol our streets. So Casillas responded to a 911 call in Santa Ana. He once again failed to assess and de-escalate a situation involving a person with mental illness. He arrived at the scene, and within 25 seconds, he jumped out of his vehicle and shot Henry Gonzalez Jr. in the head from about 5 feet away. At the scene, Henry's mother shared with the officers that he was suicidal, that he had mental health issues. You could hear it in the body cam footage that was released shortly after the events. And it's completely unjust that the officer still took this course of action. He failed to de-escalate a situation yet again. He failed to help a person in our community who is arguably one of the people who needs the help the most, right? We have a lot of people with mental health issues in our community, and that's not really being addressed by the city. In the body camera footage, we see that that Gonzalez was holding his mother with one arm, and he had a knife at his waist at the other. And as Casillas came out of his vehicle, he approached very quickly. He only issued sporadic orders in English. Like I said, Henry's mother was warning the officers that he had mental health issues, that he was suicidal, and yet these officers still came in with a very aggressive posture. They came out with guns drawn. They were approaching him, and they were closing the distance very rapidly. Much like Noe, Casillas, again, issued sporadic orders in English, and he opened fire on Henry after Henry turned around to look behind himself. That's not the kind of actions that our officers should be taking. It's not the course of action that should be followed at all. We have policies that are supposed to prevent these kinds of issues with people who have mental health illnesses. We have policies in place that the officers are supposed to follow to de-escalate these kinds of situations. Casillas' actions were later defended by Mayor Amezcua, who made false statements claiming that Henry held a knife to his mother's throat. In that same comment, Amezcua also upheld the false narrative that was published by SAPD, stating that Noe Rodriguez was loading a shotgun and waving around in downtown. Those statements are false, and quite frankly, I'm upset that Mayor Amezcua would make such comments, but she's not here. She then went on to say that despite the great need in our communities for mental health resources, officers must continue to do what they do best, insinuating that to protect and serve means to eliminate people who need the most help in our communities. Her comments serve to sanitize and glorify the actions of officers who in fact put our communities in the most danger. So, yeah.
Abraham, your time's up. The next speaker is David Pulido.
All right. Hello, everybody. My name is David. I'm a member of CSO Orange County's Police Accountability Committee. It's been a while since we've been here, but we're here again to raise the demands for justice for Noe Rodriguez, as Abraham was speaking about. And in particular, since the commission now has an independent oversight director, we're coming with the demand that we complete an investigation, an independent investigation into this incident and the officers involved. On behalf of Noe's mother, Maria, on behalf of his wife, Erika, and his 2 daughters, we want this investigation, an independent investigation, and we want these officers to be fired. I understand you have to do your own investigation, come to your own conclusions, but I mean, we've been waiting for 9 months. 9 months, we were there investigating December 2nd, and we've been doing that work ever since. So for us, every day is too late. But just a bit on the actual case, you, I'm sure have heard, but Casillas and Ibarra killed Noe Rodriguez, who was unarmed. He was having a mental health crisis when Casillas swerved towards Gasolina Furniture, swung open his door, and pointed his weapon. He gave 3 identical commands only in English: drop the gun or you're going to be shot. Ibarra gave no commands but pointed his weapon at Noe, who did not respond but stood motionless against a wall. Then Casillas fired every single bullet from his handgun and loaded another magazine. Ibarra joined in and fired 11 bullets. As both officers fired, Noe turned towards the wall and slowly collapsed to the ground. From the moment Casillas drew and pointed his weapon until the moment he began firing, 20 seconds passed. Officers failed to assess or evaluate the situation. Noe was showing symptoms of mental illness, including a lack of awareness of his situation and an inappropriate response to it. His family has shared that he was struggling with hallucinations, but he was never violent, and that was true on December 1st. But despite policy and procedure on how to assess and respond to people who show signs of mental illness, Casillas did not use any de-escalatory tactics and gave the same English command 3 times before shooting him. According to census data, and this is just well known, Santa Ana is a majority Chicano Latino city, with about 77% of its 310,000 residents being Hispanic. The non-English language spoken by the majority of Santa Ana residents is Spanish. A dispatch officer who identified Noe's race as Hispanic, Ibarra confirmed that in his post-critical incident interview, and like many in Santa Ana, Noe only spoke Spanish. Yet Officer Casillas only gave 3 commands and only in English, while Ibarra attempted none whatsoever. I have a lot more, but I'll just try and bring it to a few more points. Noe was denied medical attention because of the narrative that he was armed and dangerous, even though he had been shot over 20 times, and he was motionless and bleeding. So officers were just pointing guns at him and staring at his body. About 10 minutes later, they shot a 40-millimeter launcher at his body and then handcuffed his limp body. It was, I mean, it's disgusting, and that's in the police, footage. So, we're not satisfied with how this is being handled right now, and we are demanding that independent investigation into this incident. Thank you.
The next speaker is Karina Munoz.
Hello, my name is Karina. I'm here with CSO, and I'm come here to support my community and speak about one of your SAPD officers, Nicholas Cavendish. He is a prime example of a pattern that is shown within this police force of lack of accountability and integrity. In 2023, 2 minutes into a traffic stop, Cavendish told a civilian driver, in summary, that if I ever catch you back in Santa Ana, this body cam is gonna go in my car and I'm gonna bash your brains in. Do you understand? He then said many more threats. The incident continued to escalate as the passenger of the vehicle was thrown onto the car door and 2 other officers on the scene turned their body cameras off. This story was made public by those civilians that were brutalized and had to make the public record request themselves. They had to fight for their rights to be protected by SAPD. This incident caused the city to pay $417,500 in legal claims, which may aid in surpassing the $24.5 million that was paid out through 2010 and 2020. The lack of de-escalation skills and violence within SAPD is causing loss of funds and loss of trust of those who are supposed to protect us. Once again, I want to say I'm here with CSO and with my community, and we are here to work with the Police Oversight Committee. We demand SAPD to be held liable for the wrongdoings. We demand SAPD to be fully investigated in the wrongdoings in a timely manner, and we demand transparency. Thank you.
The next speaker is Emma Gottfried.
Hello, my name is Emma. I'm a resident of Ward 4, and I'm a member of CSOOC's Police Accountability Committee. And I wanted to talk about another victim of police violence, Mario Diaz. Ana Dominguez, the mother of the 15-year-old Mario Diaz, reached out to CSO just a few days after he was allegedly beaten by several officers. He already put his hands up and surrendered to the police, as shown in the video the department released and then later took down. This is when he was handcuffed and allegedly beaten to the ground, including by allegedly Officer Luis Casillas. And then after beating, that beating left him with a broken rib, a collapsed lung, and an eye socket fracture. The department released a video of his arrest that was set to heavy metal music, but removed the portion where where Mario was taken to the ground. This video was later taken down, has not been released to Mario's family. And Anna could not locate her son on the night of the arrest, and she first learned about what happened to Mario through a phone call from the Tustin Global Medical Center asking for consent to treat his injuries. Anna's demanding the names of these officers who beat her son. We demand that the footage of this incident be released to her family, and she's demanding that the officers be held accountable for their actions. And we believe this incident reinforces our demand that the officers involved with the killing of Noe Rodriguez be investigated. You know, Casillas has a pattern of violence that continues. These officers need to be investigated, and they ultimately need to be fired for this kind of action, these kind of actions. Thank you for your time.
The last speaker is Victor Mendez.
Good evening. I wanted to speak briefly about this proposal that would kind of revamp the commission and take the current code kind of in a different direction. You know, I too was kind of taken aback by it, very surprised by it. A lot of time and energy went into preparing that code. I thought we had something good. Come to find out, you know, I guess, you know, things are going to perhaps be different. And that needs to be worked out, but there's definitely a failure in that respect. That said, I was very, this is public comment, ma'am. Ma'am, public comment. Restore my time, please. That should not happen during public comment. Could I have my time restored, please? Thank you. That should never happen during public comment. Thank you. Could you restore my time to 3? Thank you. Thank you. Anyway, so like I said, I was taken aback by this proposal, but I heard the newly appointed independent commissioner or independent director speak, and he spoke some really cogent reasons why it's best to go forward in another direction. And he had some good experience about Oakland. And the funny thing about it, also this process, I don't think anyone ever talked to Oakland as to what they were doing and how it was working out. And we come to find out maybe it doesn't work out too well. I think there's a lot to do to take a reform approach to this. They can be much more accomplished in quicker time. You can look at the internal or the internal affairs organization, you can look at the process, and I have filed a internal affairs complaint. I wasn't very satisfied with the process. Wasn't satisfied with the outcome, but that's another matter. But the process, which I thought took over a year on a pretty straightforward matter, very simple complaint, that could be looked at. Certainly, you can look into a brief on specific issues, such as how the police handled the recent protest, have an evaluation on that. This whole issue with this internal investigation by the city manager, why did that happen? How can we prevent it happening again? All this can protect the officers involved as well. A lot of internal, investigations can be done. You can look at, police strategies and what needs to be done. You can look at overtime and how that's being deployed. You can prepare a confidence report on the police, prepared by the commission. We get a confidence report that costs us $50,000 on our water. We know our water is good. We don't need $50,000 to tell us our water is good. We could spend $50,000 to tell us how our police are functioning, what type of confidence the community has, where they need to be improved. That, to me, is a very good tool to move forward and puts us in a more strategic frame of mind. Like I said, I think this direction where there's more reform-oriented, more improvements-oriented, I think that's the way it will certainly go. One of the other things that comes to my mind, though, is how does an independent commission do an independent investigation work when there's a claim, when a claim arises? You have a lawyer coming in, then we get issues of legality exposing the city. Where does that independent investigation go? I think it just opens up a whole can of worms that we don't need to go down. We have a process with internal affairs, and I think through this way, a lot of questions can get answered, and a lot of matters can be resolved. So, like I said, I'm taken aback. I didn't really like it this way, but I think getting where we need to go is going to be okay. I look forward to hearing what you have to say at this forthcoming joint meeting. I'm not sure what the goal is, quite frankly, but I wish you well in it. I hope something comes of it. Thank you very much, and thank you for restoring my time, sir.
You're welcome.
Next speaker is Erica Armenta.
Buenas tardes, mi nombre es Erika Armenta y vengo aquí a hablar con ustedes pidiendo que por favor esta comisión funcione con investigaciones independientes porque hay casos que están sucediendo en la ciudad como le pasó a mi esposo Noé Rodríguez. El 1 de diciembre fue asesinado por oficiales del departamento de Santana. Le dieron más de 30 disparos cuando resultó que no portaba nada, un arma falsa, ni no portaba un arma mortal. Los oficiales llegaron a la escena y en menos de 3 minutos terminaron con él. Es una situación muy triste que está sucediendo, más que estamos en una ciudad donde la mayoría somos hispanos. Noé solamente hablaba español. Recibimos los nombres de los oficiales involucrados por medio de registros públicos. Ahora yo tengo el nombre de ellos y es muy peligroso que ellos andan libres patrullando nuestras calles mientras están siendo investigados por el asesinato de mi esposo. Sé que el Departamento de Justicia está llevando a cabo una investigación, pero es muy importante que tomen medidas para evitar que esto siga sucediendo mientras ellos están siendo investigados. La comunidad y yo yo temo por mi vida, por la seguridad mía y de mi familia. Por favor, necesito que se haga justicia y que me escuchen y muchas gracias.
If you'd like, I could provide a brief summary of what Erica just stated.
That would be appreciated.
Okay. So she spoke regarding her husband, Noe Rodriguez's incident, and she requested justice for the incident. She mentioned she is scared for her life and for her families, and she requested that the commission do their diligence and investigate these investigations related to incidents like hers.
Thank you.
And I have no additional speakers.
I'm sorry?
There are no additional speakers.
Thank you. Okay, the next item is the consent calendar. Items 1 and 2, is there a motion to approve the consent calendar?
I'll make a motion.
Do we have a second?
I'll second.
Thank you. Madam Secretary, please conduct the roll call vote.
So I have a motion by Vice Chair Castillo-Lofton, a second by Commissioner Said, and that was to approve consent calendar items 1 and 2. Commissioner Goronsky? Commissioner Mejia?
Yes.
Commissioner Perea?
Yes.
Commissioner Said?
Yes, thank you.
Commissioner Vega?
Yes.
Vice Chair Castillo-Lofton?
Yes.
Chair Carpenter?
Yes.
That motion carried.
Okay. Next on the agenda is a study session. Item number 3 pertains to U visa work study.
Commissioners, good evening. At the July 10th Police Oversight Commission meeting, there was a request to bring in 2 groups to review presentations regarding U visas. And that presentation is from Sandra Deanda with the Orange County Rapid Response Network and Fabi Jacome of the Orange County Justice Fund. In addition, this work study session, we will review and discuss proposed red line changes to the Santa Ana Police Procedure presented by Jack Morse to see if this is something that you would like to recommend for the police chief's review and implementation. And at this time, I can call Sandra and Fabi up to present.
Good evening, everyone. Thank you so much, Police Commission, for allowing us to be here today. This has been a labor of love from a lot of community members, including the very first Sanctuary Board back in 2020 started to raise concerns around the U visa policy, and also, many of the folks that navigate this process in the community who have brought this forth. I also want to thank, Fabi and I both want to thank Councilman Vasquez and Councilwoman Lopez for allowing us to, have space in the chambers. They really helped us put this front and forward back in the fall of last year. Lastly, I'd also like to thank many of the women and femmes and LGBTQ community leaders that have done extensive research on this. And as we know, many victims of crime are LGBTQ community members. And so I just wanted to share those remarks. I don't know if you want to share anything, Fabi.
Yeah, I also want to say thank you to the commissioners that are sitting in this body right now that advocated for our organizations to come forward and share some of this information with you all, and then just the rest of you for listening as well.
So this is the agenda we have set forth today, and we can go to the next slide. So myself and Fabi will be introducing our organizations. I'm with the Orange County Rapid Response Network. You may be hearing a lot more about us as we respond to hotline calls from Santa Ana residents who are experiencing immigration enforcement. We do Know Your Rights and ICE Watch trainings, and we also accompany individuals to both the justice centers and also the immigration court on Dyer, where unfortunately many asylum seekers are being detained because their cases are being dismissed. But yes, we provide accompaniment and support. And so far, we've actually received more than 4,000 calls since January 20th. And so we have responded to hundreds of enforcement incidents throughout the county. We've trained hundreds of residents to know their rights as legal observers, as ICE watchers, and in their residences and businesses. And we have also built a trusted network of volunteers, advocates, and defense attorneys on the criminal defense and immigration side.
And again, my name is Fabi Hakome. I'm the executive director at the Orange County Justice Fund. We are an immigration bond fund. Oh, if I could go to the next slide, please. Thank you. We are an immigration bond fund here in the County of Orange. We have helped around 108 community members be released on bond, a lot of them coming from the city of Santa Ana. We're also working on advocacy and policy, and we work under a legal empowerment model, which we utilize through legal clinics and educational events where community members can meet with advocates and attorneys to learn about their rights and how different laws affect them. We work constantly with school districts to be able to provide them, their families, their staff with Know Your Rights materials, as well as now family preparedness. And we partner with coalitions, some of them coming out of here, the city of Santa Ana, to just make sure that we have policies that are friendly to our undocumented and immigrant refugee populations here in OC. I gotta go to the next slide. And so I wanna acknowledge, one, that we're here to talk about U visas. We're not gonna get into the technicalities of them. You all heard that from two very amazing attorneys that gave a presentation at your last meeting. But I do want to remind y'all a little bit of what a U visa is. It is a federal immigration relief for victims of certain crimes who assist law enforcement. The purpose is to encourage victims to report crimes and participate in the detection of crimes, investigations, or prosecution without fear of deportation, in keeping with humanitarian interests of the U.S. The certifying agency role is to certify the rebuttable presumption that a victim is beneficial, has been helpful, or is likely to be useful to the detection, investigation, or prosecution of that qualifying crime. However, and I'm going to kind of be repeating it throughout the presentation, the job is not to decide the final immigration outcome.
Since we've heard from many non-citizens that have faced a crime against them, we took interest in the data around how many U visas were approved, denied, or referred elsewhere. And I want to thank the folks at Chispa who helped us PRA this information. And so from 2017, right, we already begin to see a high denial rate of U visas. That trend continues into 2025. Right now, actually the approval rates got a little bit better in 2025, but not enough to, make a dent in preserving and protecting our community members. But yeah, this is some of the data that you guys can refer to. Of course, as advocates, we want as many certifications to come out of the city of Santa Ana, and that is why we're here today, to improve these numbers. So what do these numbers mean? From 2017 to 2025, about 53.1% of U visa requests were denied, while 40.8% were approved on average. In 2024, 44.7 were approved, 28.8 were denied, and 26.4 were referred elsewhere. As of May 6, 2025, 42.4 were approved, 21.1 denied, and 19.8 were referred elsewhere. Right now, there's little to no publicly available information on where the referred elsewhere cases went in 2024, 2025, and prior years, making it unclear how these cases were ultimately handled. Fabi and myself work on the ground with a lot of individuals who are victims of crime, and we see the human toll with each case. As we know, each certification decision can shape the future of victims and their families. Ramifications can ultimately result in the deportation of individuals. And to elaborate furthermore, U visas, while they allow individuals to seek an avenue of relief, it also allows folks to seek a sense of justice. And so, a U visa allows people to process and try to consider some form of justice or closure. So it is a very profound, mode of an avenue of relief, right? So the denials in gray area cases can cause long-term harm that could otherwise have been avoided, of course, on the case side, but also on the very emotional side. And, myself, Fabi, and many of us in the room right now know that the conditions inside detention are just completely awful. And, we want to be able to allow this process to exist in order to help more folks not enter the very robust and draconian detention system. The process is not about predicting USCIS decisions. It's about allowing the community the opportunity to apply. As I had mentioned before, so women and children are more likely to be victims of crimes. The humanitarian interest of the United States to protect victims of crimes is clearly stated in this avenue of relief. Also access to police reports and the right to petition. Understatus immigrants have accessibility barriers to making police reports. We know this because we host a Wednesday community space called our Participatory Defense Space, where many families, try to understand how to go and get a police report or have an attorney get that police report. But of course, with so much distrust, especially in this very moment of enforcement agencies, we're seeing individuals who do not even want to access these police reports, which is one of the very first steps to we're opening a U visa case. And so an accessible and legally precise U visa system is crucial in fostering community trust and safety, and enabling immigrants to call 911 and make reports. I know a while back, Chief Rodriguez had shared that the police department got around 6 calls regarding to kidnappings, or what we are seeing now, right, mass enforcement and detainments of our community members. But our organization, as I had mentioned, we've been getting more than 4,000 calls regarding the matter. And so ultimately, right, this policy aims to help you, the Police Oversight Commission, give this recommendation on improving its policies to the police, because right now we need to build that bridge, that trust. And so we know immigration law is very complex, right? Myself, I am a legal advocate, and the work that I do is basically mincing and being able to work with attorneys to help our community members understand how to navigate these avenues of relief in a way that they can understand. And so I understand that it is very difficult to interpret immigration law, and we're non-attorneys, but we're also seeing that on the side of the certifying officers. They're interpreting such an act to determine the crimes the victim is experiencing requires a profound understanding of immigration law. For example, what is considered felonious does not align one-to-one with state law. That is not the duty of our certifying officers. That is the duty of a USCIS officer. But we only bring this up because through several of these U-Visa applications that our community members come forth with, there are responses in which these crimes are being elaborated on, even though that is not the role of the certifying officer. So immigration officers will assess the validity of the crime when assessing the U-Visa, and local law enforcement deciding about the qualifications of a crime under immigration law not only makes them liable for immigration consequences, it is also an overstep of authority and responsibility. And that is a very, very important thing to note, especially now in which our communities are trying to decipher which agencies are in our community and what these agencies do. So we do not want, this misinterpretation of the roles of certifying officers to come off as deputizing our police to do immigration analysis, right? And so I think this is a very important component of the U-Visa, where we do not want our police officers interpreting immigration law. And of course, with any legal processes, there are legal obligations under California law. So there is the standard for 30-day response to all certification requests. If an individual is in removal proceedings, they have the certifying officer must respond within 7 business days. Detailed written explanation required for denials, including specifics on cooperation requests and denials, must be given to the attorney or pro se litigant, and the law requires that the victim of the crime is given rebutable presumption of helpfulness with 1, detection, 2, investigation, or prosecution, not and. You guys can use a mnemonic, just use DIP, detection, investigation, or prosecution. And a strict legal reading shows that helpfulness would need to be rebutted for all 3. It is presumed that the person coming with the U-Visa application to the city of Santa Ana is someone that will be helpful. And then we had to emphasize and because we are getting the sense that, certifying officers are wanting detection, investigation, and prosecution to be all the modes of helpfulness, but as I mentioned, it can either be detection, investigation, or prosecution.
I'm going to give a little bit of community perspectives and experiences. These are coming from some of our local partners, along with just experiences with the community members that we work with. But one thing that I did want to bring up before going specifically into some of these cases is the respect for professional roles. Often a U-Visa request comes through an immigration attorney or accredited representative. That means that the legal professional has already evaluated the case and believes it's viable. So we've seen delays well beyond the legal deadlines, including in cases where victims were in removal proceedings and should have been prioritized. In one case, a request submitted in early July didn't receive a response until mid-August, which was more than 40 days later. And the victim was incorrectly referred to another agency with inaccurate contact information. This person specifically was in removal proceedings, and so they, again, should have been processed within those 7 business days. And these protections, these delays have real-life consequences. Missed filing deadlines, lost opportunities, and prolonged danger for victims, and now it comes with an added risk, especially if the person is in removal proceedings, of just deportation. Next slide, please.
Can we ask throughout the presentation questions, or do you rather wait till the end?
I think rather wait through the end,
Okay.
just so we don't lose our place. The next one, the next documented noncompliance has been wrongful denials. We've also seen denials that do not align with the law, for example, citing lack of helpfulness when the victim was never contacted, or dismissing a domestic violence report as not meeting the threshold despite a restraining order being in place. Another troubling pattern is denying a case because an officer believes USCIS will not ultimately approve it, which again goes back to my initial slide of the job is to certify, not to make decisions as if they were USCIS. And again, that's not the officer's role, and it violates both the spirit and the letter of California law. Next slide, please. I have some case examples as well that we didn't put on the slides. The names of some of these community members have been removed for privacy, but we have an example of a robbery at gunpoint where the certification was denied for unhelpfulness, although the victim says the police never followed up. We also have another, again, of the domestic violence survivor with a restraining order, and was told by the certifying officer that her case wasn't domestic violence. And we have a sexual battery victim who was denied because they supposedly didn't want to prosecute, despite no evidence of that. And each of these denials was avoidable and had life-changing consequences for our community members. The law requires specific detail in denial letters, but many victims are receiving only vague statements. Again, the kidnapping victim was denied for failure to report promptly, despite explaining that the threats to his life and severe trauma delayed his report. This lack of specificity not only violates the law, it robs the victims, the community members, of the ability to understand and address the reason for denial. The next thing that we would like to address are youth victims and trauma-informed approaches. One area where we see a consistent gap is with youth victims. In one case, a minor who had been beaten by 2 adults was questioned about possible gang involvement instead of being given the support as a victim. This approach eroded trust, and the youth refused to prosecute, not because the crime didn't happen, but because he no longer trusted the system. When we fail to approach young victims with sensitivity, we risk losing critical cooperation and re-traumatizing them. And again, there's code throughout the presentation that I'm not addressing because you also have it right in front of you. So next one, please. Oh, I keep looking at you and I just realized it was done. Next one, please. You're good. SIPD's procedure 4130 leaves too much ambiguity about how qualifying crimes are determined. It lacks a clear appeals process and does not adequately address the needs of the child or youth victims or victims. The result is inconsistent outcomes, confusion for victims and advocates, and a higher likelihood of wrongful denials. And the last part that we have is consistent and overzealous referrals to the DA's office. There is a community perspective that most, if not all, U visas at SAPD are sent to the DA's office for review, and are hinging certification based on cooperation with the DA prosecution. Again, I don't want to get super duper into the weeds, but I think one of the recommendations that we have later in the presentation is asking for y'all to revise that policy as well. And so we've given some examples throughout the presentation. And so again, these are, again, SAPD policies on referrals, all U visa requests, and this is coming straight from SAPD 4130. And so this policy exaggerates the importance of helpfulness to DA prosecution and excludes other categories of helpfulness, including detection and investigation. And we believe that it violates California Penal Code, as it does not reflect helpfulness as defined. Next, please. So our core question for law enforcement today is the mindset shift we're asking for is simple. Instead of asking, why should we support this victim? Will USCIS approve this case? Which again, that's not y'all's job. And how do we benefit as law enforcement? We are asking you to consider how can we best support this victim's request in a timely and lawful way. Our job is to remove barriers for victims, not add new ones.
So we're going to work through one of the case studies of the sort of cases that we support community members with. As I had mentioned, or I'll mention again, many folks who experience or are victims of crime know it, right? They know there was some sort of violation done unto them, and that is why they feel secure to move forward with the request of a U visa. So in this situation, a community member believed they were the victim of a crime in Santa Ana, so they went ahead and they consulted with a private immigration attorney. The standard within the orgs that Fabi and I partner with are pro bono attorneys from Immigrant Defenders, Public Law Center, and so many of the folks that we work with will either retain a private attorney or go through these legal providers. So of course, with this security, the attorney submitted a request to the records division for the police report and all related documentation concerning the incident of the crime done unto the victim. Within 7 days, the police report was provided to our community member and his attorney. And through the police report, they said they reaffirmed that, yes, this looks like we have enough evidence in the police report to say that you were a victim of a crime. With this documentation, both the community member and their attorney felt prepared to meet the eligibility and legal requirements outlined in Penal Code 4130.3 for a U visa in Santa Ana. So now, after they have gathered that report, the attorney now submits a Supplement B U non-immigrant status certification to Detective Sergeant Sandy Kim and Chief Robert Rodriguez, with all relevant findings and reports attached. Because the community member was in removal proceedings, Sergeant Kim was required to respond within 7 business days. She provided the response within that time frame. So when the community member and the attorney got the response, Sergeant Kim stated in a letter to the attorney that the community member was a victim of felonious assault, which is not really her duty, right, to say what type of assault it was. But supplemental reports later cited as saying the community member was uncooperative and did not want to press charges. That is the email she sent the attorney. And based on these supplemental reports, they were not provided to the attorney when first requested at the start of the process. And these reports were also withheld in the I-19 denial. And so the attorney and the community member were like, what reports are they talking about when they should have already handed us over those reports at the get-go, or at least at the end of the process? The rejection was summarized in only a few sentences. There was no evidence, of course, to prove that this community member was uncooperative and did not want to press charges. While the community member did not participate in prosecution, according to this attorney's very detailed analysis of the case, they met the helpfulness threshold at the time of the incident. In real time, they never failed or refused to provide information requested by law enforcement during the investigation, and also assisted in identifying the assailants. Also at the moment of detection, where it is that the police department uncovers the crime, the person was also very forthcoming in assisting the police department. So according to the attorney's arguments and requests, the community member met all eligibility standards under Penal Code 4130.3. So this type of case is not uncommon. And so what I want to reflect on is sort of I wouldn't necessarily call it universal, but it is a very common trend that we see in these cases that come before us in the community as legal advocates. So this case shows the lack of transparency in the I-918 denials, decisions being made without evidence. It points to non-compliance and a certifying officer's limited understanding of immigration law. Because of these missteps, our community member is currently detained in ICE custody at the very moment, despite being eligible for this petition. I feel like, and I don't want to interpret law either, immigration law, right? But there was so many missing components to Sergeant Kim's response to the attorney that it raised flags and it started echoing in terms of how we began to see these cases. And it's good to note, right, the mnemonic dip. And so that's something maybe that can assist you all in figuring it. This is not something up to interpretation. This is really just checking off some boxes in terms of helpfulness in the investigation.
So I think one thing to keep in mind, and I've been a paralegal for over 10 years and have worked on U visa cases and VAWA cases directly with community members under the supervision of an attorney, is that a lot of the time these situations are some of our community members this is the worst or one of the worst times of their life. And especially for youth. And so one of our training or one of our recommendations or immediate actions is training for key personnel. All staff responsible for U visa decisions should receive specialized training from a reputable legal service provider with expertise in SB 674 and federal U visa law, and refrain from making immigration legal opinions and rulings on the crime experienced by the victim. And I would like to add on there for it to also be like trauma-informed, a trauma-informed training, right? So that they can keep that into consideration as well. We would also like to ask for multilingual access, so to provide updated U visa information and resources in at least English, Spanish, and Vietnamese on all OC Cornerstone languages on the city website and in printed outreach materials. Website and transparency updates. There have been some website updates since the last time that we met with some of the city staff, and so we're very thankful for that. However, one of the concerns that I brought up during that meeting is that as a paralegal, when I started filling out and submitting these forms to the Santa Ana Police Department, I had to really look at where and call a lot of phone numbers. There are folks that have the ability to have representation even throughout the Supplement B submission, but there are other community members that don't have either the funds or our legal service providers don't have the capacity to take on some of these cases. And so kind of putting on there a clear place, either an address, there is a form, but again, we're looking at folks that have representation, but we're also looking at folks that don't. And just kind of, there are attorneys that charge for a Supplement B, and that is the initial step. As you all have learned through PLC and Western State, that is the initial step for folks to be able to move forward with their U visa. If they don't have a signed Supplement B, they cannot move forward with it. But there are attorneys that charge hundreds of dollars for them to be able to submit this with local law enforcement. And so there are some community members that try to do this pro se or on their own, but the website still doesn't have clear information as to where they can go for questions and these aren't legal questions, right? These are submission questions. So it's still not there. And to publish current approval, denial, and referral statistics so that we are aware of some of the work that the police department is doing and to be more transparent with our community. Next one, please. One of our policy recommendations is to adopt the rebuttable presumption of helpfulness as stated in California Penal Code 679.10, which explicitly states in SAPD policy the victims are presumed helpful unless there is a clear evidence of refusal to be helpful on all three categories of detection, investigation, and prosecution. And to create a short, practical rubric to guide determinations of helpfulness and ensure consistency. Because again, that's one of the biggest issues that we're seeing, as well as enshrine the cooperativeness is a factor of the rebuttable presumption of helpfulness and not a legal synonym. And to train all officers and supervisors on SB 674 and updated state federal U visa rules to ensure consistent application delivered by a reputable legal service provider. Next one, please. We would also like to ask to eliminate and if not possible, limit the DA referral policy to process all certification requests in-house regardless of whether a case is prosecuted. SAPD's policy of steering nearly all cases involving arrests or referrals over to the OCDA is not mandated by law. Instead, it reflects a discretionary policy that goes above what legal requirements dictate and only refer to the DA when legally required with written notice to the victim and tracking of the outcome. And if any referral to the DA is unavoidable, follow up within the statutory timeline to prevent victims from falling into limbo and inform the victim of the immigration consequences of not meeting the DA's request. Please. And the last one for me is to create a formal appeals and review process for denials, establish a transparent public process for victims or their attorneys to request reconsideration of a denial, and require a different supervisor to assess appeals, ensuring an independent check on the original decision, and to allow resubmission if new evidence of helpfulness arises.
Our next recommendation, second to last, is to create a formal appeals and review process for denials. Establish a transparent public process for victims or their attorneys to request a reconsideration of a denial. Oh, we did that one? Okay, let's do the next one. Sorry. Following Oakland's example, conduct an internal review of past denials to identify cases where the denial violated SB 674 or current law. Produce a public audit report for the city council that aggregates findings and makes them available to the public. Proactively contact eligible victims to invite them to reapply and offer assistance. And finally, this issue came forth because of issues of transparency in terms of data, right? We are still missing some data around the DA, number of DA referrals. And so, right, publish annual U visa certification statistics on the city's website, detailing the number of requests, approvals, denials, referrals to the DA and other entities, and appeal outcomes along with corresponding percentages. Provide, again, written denial letters with specific reasons tied to the law, not vague language. Offer multi-language U visa resources at minimum, English, Spanish, and Vietnamese, online and in print, explaining eligibility, the application process, and timelines. And partner, of course, with community-based legal providers for outreach and application assistance. And I believe that's the last slide. I do have some closing remarks, and if Fabi wants to make some as well. But this process is very, very important to our community. And, you know, I personally feel like it was maybe not working to its best capacity, right? There was some issues with compliance that we have noted. And also the U visa manual leans more into prosecution, which can interrupt many of our community members' sense of personal justice. Many of our community members that are victims of crime are scared to prosecute, right? Because they fear they will be retaliated, or ultimately it is not in their vision of justice. And so we want to see this U visa policy enhanced and followed because we are living through very difficult and dangerous times for our immigrant and refugee communities. And, you know, just through our experience, we know that many folks are already facing these crimes of hate, right? And so we want to make sure that this is an effective policy that is accessible to all, that also allows people to find their own sense of justice within this city process.
And I think likewise, and again, highlighting the fact that this is the first step to a U visa. Once a police officer certifies it, there's a whole lot other steps and a lot of other things that community members have to do, including like psych evals and like things like that. And so we want you all to keep those in mind, or to keep that in mind, especially now, and especially for folks that are either going through deportation proceedings or that are sitting in detention centers that could have been avoided. And also wanted to thank you all for your time and again, the opportunity to be here. And yeah, we're open to taking questions.
Thank you both.
Thank you very much. Questions? Commissioner Mejia?
Thank you both, Sandra and Fabi. And sorry if my voice is shaky. I'm freezing in here. I forgot how cold it is. And so it is because I am freezing. And so I had a couple of questions. One on page 7 to us, but it's your slide on documented noncompliance timing. And in particular to the case where the client was, you have here incorrectly referred to DA with wrong contact. And I was wondering if they had given the reason as to why they were referred to the DA. So was it that they were wrongfully deferred to the DA, or both wrongfully deferred and with the wrong contact information?
I believe the information that we received from the legal service providers was both, that they were not notified, that they had been moved over to the DA's office, and they were given the wrong contact at the DA's office.
And they
So
shouldn't have referred him to the DA's office.
Again, I think it depends on specific policy, which is part of the recommendations that we have to revise the referral policy to the DA's office.
And correct me if I'm wrong, but based on the last presentation, I recall that there's no need to refer, right? That the Santa Ana PD has the authority to grant and certify, and I'm assuming Santa Ana PD, you can answer, that decision is probably made through logistics rather than policy. So I just wanted to clarify, that's correct, right?
Yes.
Okay, great, thank you. And then my other question was, this is something I kind of brought up last week, sorry, I'm so freezing in here. Last meeting was about the DV, and I know you mentioned that it wouldn't have been an issue. And so my understanding here is that the client was denied because they were told that their qualifying crime was not considered a DV. Do you have a little bit more information on that you can share?
Not that we can share.
Okay, I understand, and maybe you can answer this in a different way. So one of the issues that it is with DV, right, is that sometimes depending on the filing of the crime, it can be battery or domestic violence. And so my understanding, which is what I had asked before, was precisely for this reason, we need to be clear that battery can also be considered domestic violence. And so my understanding was that it wouldn't be an issue. And so I'm just trying to understand where this, whether it's a policy issue, a practice issue, misinformation, misunderstanding, so that we can address it properly on the policy.
Again, I think answering that question specifically because that would be a question that would need to be answered by the legal service provider that was working specifically with this community member. But my understanding is that a portion of that had to do with like stalking. And so that was one of the reasons why it was denied.
Thank you. And
Commissioner Pereira. That's what we're here for.
okay, give me one second. I just write them as they come.
Can we increase the temperature in here because it is freezing up here? Or at least stop the AC? Is there a motion? Yes, I motion to increase the temperature in here.
Just go because I asked one of them and I need to clarify the other one.
Thank you. Thank you, Chair Carpenter. First and foremost, thank you, Ms. Jacome and Ms. Deanda, for the presentation. I'm really glad that you were able to provide us with additional information, and I really appreciate also the case examples, because at the end of the day, we're talking about real people and real families. So I really appreciate that information. So because I want to make sure that the commission has context and we're able to really understand why is it that we got here, right? And why this issue hasn't been addressed. But first, I think there's a lot of overlap of policy recommendations and recommendations for the Santa Ana Police Department that the commission has heard from our previous presenters from Western State College of Law and Public Law Center. And so I think that this reinforces the need as to why we need to revise this policy. I have my portion right now is a mix of questions and also comments / recommendations for our Director Morse, but I first want to clarify the process, Director Morse. So can we, in our comments right now, give you recommendations for revising certain portions of the policy, or should we schedule a separate time for that?
Now is fine, or you can wait. It's up to you, really.
Okay, and will you need the majority of the commission to give you the same kind of guidance, or would it be just that you take and bring us a draft?
As long as, I'm looking at Jonathan here, but as long as commissioners don't disagree on what a recommendation is, I'm happy to incorporate it.
Okay.
I think that for a commissioner to make a recommendation, which would ultimately or potentially turn into direction to staff, I think in my analysis that would require a vote or a majority of the commissioners to convert that to a direction. If it's simply a recommendation for which staff, meaning Director Morse, can consider, that I believe is appropriate just on a commissioner by commissioner basis. But again, for that to convert to direction, I believe that that would require a vote.
Thank you. That will mean a motion, correct?
Correct.
Thank you. Because I want to make sure that we, since we're going to start now getting into the weeds of the policy and the recommendations, that we understand how to do that and hopefully move on this now in the proper manner. Okay, so with that said, so it is my understanding that this issue has been brought up previously, right, to city leadership. Do you mind explaining to us kind of like what has, like where did it start? Why hasn't there been any movement there? And I see our city manager here. Some of these problems predate you, so please do not take it personal, but please feel free to give us also context so we understand. But yeah, if you can kind of like walk us through what has been the work here.
So I think I can talk about the involvement of the Orange County Justice Fund and the communication that we have had with city staff. And I know the Rapid Response Network kind of predates us being involved in these policies as well. But one of them had to do with a bond fund recipient, and it was brought up to us by one of the legal service providers. And so we were in the denial of that U visa and taking a look at the the policies within the Santa Ana PD. So it was brought up by an attorney. We requested a meeting to voice some of the concerns that we had. That meeting was then made available for us to speak to city staff and give some recommendations, again, like posting information on the website and making it a little bit more clear for community members to access. Yeah, I think that's kind of the portion of it that I have. I think it's taken a little bit of time, and I think it's just conflicting schedules for a while. But, you know, again, I want to be thankful to the Santa Ana city staff for being engaging and for taking the time, and to some of the elected officials like Councilmember Vasquez and Councilmember Lopez for taking the time to meet with us and hear us out on the concerns that we had. And my understanding is that some of those recommendations that we made were put into practice, so thank you so much for that. And so these are just kind of additional ones as well.
Yeah, so basically, under Trump 1, there were many community partners that came together in something called the Sanctuary Board. This included, different attorneys, health workers, and also even private attorneys that came together and saw this as a big issue. I mean, ultimately, the U visa process is a deportation. It's an avenue to stop deportations, which is, of course, like the intent of myself and Fabi and many of our community members' intent. You know, Santa Ana has a strong tradition of fighting against deportations. And so, you know, I know in 2020, the Sanctuary Board under Trump 1 started gathering a lot of information. And recently, last year, it got this interest in the U visa came forth because several of community members that are both bond recipients at the Justice Fund, but also active community members within our participatory defense space, you know, were denied U visas. So then, of course, we started to look, deconstruct the process. What happened? Why, you know, why were these U visas not certified, right? So in that deconstruction, we realized, you know, the trends that we have shared with you now. And so I know, like, we tried to bring it up early on last year, right? We tried to set up a sanctuary board, basically kind of say, let's get the sanctuary board to move on this again, especially as we get ready for or are in the midst of mass enforcement. So it came about in that way, ultimately as like a last hurrah, because under Biden, and I don't know if you guys know this, but right, ICE agents had a lot more discretionary power, where because we were working under Mallorca's enforcement priorities, which actually enforcement prioritize individuals with aggravated felonies, there was much more leg room to negotiate with ICE officers, right? They would give us timeframes to say, all right, make sure this petition is done within the next year, or I'll give you 2 years so you can handle your family petition or whatever it is that needs to be handled. Unfortunately, as we know now, these ICE officers have less discretion, and now they are, playing a numbers game where it doesn't even matter if you have a petition. It's not gonna help a lot of our community members in the deportation proceedings. So that's basically what it came out of a moment of crisis and trying to build a line of defense, because this is maybe the only deportation loophole in the city, right? Let's make sure to enhance it, and that's why we've been trying since August to really put it on y'all's radar, on the city's radar, because, right, as legal experts, we're about to face a cliff of mass deportations, and how is it that our U visa policy is not working? And so that's why we brought it forth.
Thank you for that context, and I bring this forward because this is one of the tasks that the Police Oversight Commission, we can have the most impact in issuing recommendations to not only police department, but strengthen our policies, particularly when it relates to our immigrant community. I remember, and I'm looking at Ms. Jacome here, because both of us were involved in the writing of the sanctuary ordinance, and we specifically remember at the time we included the Sanctuary Advisory Board because we did not have an oversight commission back then. We needed to ensure that we were in compliance and we were going above and beyond in doing the best that we can to serve our immigrant communities. However, I do remember this conversation came up, the U visa process, with one of my colleagues, Alexis Navatador, at the time. We brought forward the U visa concerns as well back then with the Sanctuary Advisory Board. And the issue that we fell into is the Sanctuary Advisory Board is under the city manager's office. It's at the discretion of the city manager's office. A lot of the recommendations that we gave at a time to the police department, concerns about lexical language making into our sanctuary ordinance, really fell under the discretion of the different city managers now. And so there was no real oversight on how to implement and how to really hold SAPD to ensure that they made these changes. And so that's why I am very happy that this is forward here, that the commission has engaged now in 3 sessions discussing the U visa certification issue to strengthen it, and why I think that the Police Oversight Commission is the best place to oversee the implementation of the Sanctuary Board, because we bring forward publicly, transparently, these conversations, and we actually can give guidance to the police department, which is way better than what we had at the Sanctuary Advisory Board. So I am really glad that that this has come into fruition. So with that said, I do have a set of recommendations, Director Morse, and hopefully I can get the support of my colleagues to get a majority so we can directly make this.
Commissioner, I just want to jump in and provide some clarity on the process. Feel free to share anything you would like Mr. Jack Morse to recommend, and you can say it now, you can say it via email like he stated. What we'll do, we'll incorporate all of those comments and then bring that back to you for review and approval to recommend to the police chief.
Awesome. Thank you for that.
You're welcome.
For that commitment. I just want to make sure we get this done.
And I'll just jump in here briefly. So it was a misunderstanding in the sense that I was under the impression what you wanted to include would become like the final product.
No, the
so
draft.
If this is simply recommendation to be brought back for approval, then that would be the more streamlined process.
Awesome. Thank you. Okay. So the first one, I don't believe that we should have advocates constantly PRA the city for information that we should already be providing. And so I would like this for the commission to receive annual reports on the number of cases that the Santana Police Department has received, certified, not certified, reasons why, etc., but also the number of cases that have been transferred over to another agency. I think this is very simple data that the report that the commission should be receiving. The second one is the issue of helpfulness has come up multiple times, both in this presentation and the presentation before. I think that there needs to be some better guidelines around the helpfulness determination. We do have some language provided by the Rapid Response Network, OC Justice Fund, Western State College of Law, and as well as Public Law Center, so we can take a look at those provided in our documents. I'm also particularly interested about setting reasonable guidelines. One of the issues that has been mentioned on the issue of helpfulness is whether or not we take into consideration the point of view of the victim as to whether or not it was reasonable or unreasonable for them to collaborate with the police department. I think that setting those will give ample flexibility to the officers certifying your visa to not be sort of rigid on denying applications. The other one is the process for appealing denials that was presented today to us. So I would like to see some type of language on whatever comes back. The other one, which is I'm very concerned about, and I pulled the data that we had from the presentation from the police department officer that is in charge of certifications from 3 months ago, and to the question of how many of cases have been kind of essentially handed over or deferred to the district attorney. I believe it's roughly about 30% of the cases from the data provided by the police department at the time, or what they call not best suited for the police department. I think that one of the clarifications that we got from our previous session from the attorneys was that there's nothing on the law that requires the Santana Police Department to transfer the cases or defer the cases to the district attorney if there's just no requirement. The only requirement is whether or not the victim was helpful to the investigation in whatever degree. And so I do believe we need to revisit that. It's a high number of cases being transferred over to the district attorney of things that we could be helpful at the police, at the city and the police department. The other one is I believe we have a model from Oakland that was presented to us at the last session, particularly around accessibility of information and navigation of this on the website and the public website. That includes the reports, that includes information for residents to better understand the process and the certification. I do want us to have a robust system for that on the website. So those are my initial kind of like recommendations for the core of where we're trying to get at. So thank you.
May I make a quick comment? Yeah, so thank you so much for recommending those. Carlos, you know, and Fabi and others that were in that room, you know, we realized and we've been knowing there are no immigration experts within the city of Santa Ana, right? And our very first meeting with Chief Rodriguez, you know, Councilwoman Lopez and Councilman Vasquez were present, and they had shared with us that one individual in the room said that they did not even know that this policy was within the city. And then Chief Rodriguez had shared that actually U visas get lost in the records department. So, right, there is currently no immigration experts, aside from community experts, right, like Carlos and Amalia, within the fabric of the city, right? We don't have immigration attorneys navigating these waters that we are in. And while I agree that the U visa policy should remain within the police commission oversight board, I think that immigration is much more, you know, robust than that, right? I know the Sanctuary Board was created in the spirit of health and well-being. A lot of what we are seeing right now, and I mean, I still think, and you know, if I take some time to chat with folks from the city, I would still recommend a sanctuary board, because sanctuary is a concept that constantly changes over time. We are creating within our community a new conception of what sanctuary is. But because I see the city as a ship, it needs to be manned by immigration experts. And it doesn't always have to be attorneys. It can be health workers that are working closely, right, with community members. But it has to be a very nuanced approach beyond what we're seeing with U visas, which is at the intersection of your expertise. But you know, sanctuary is much more broad. It cannot solely stay within the police commission, because it's just bigger than that. And so those are just some comments.
Sorry, just one thing to add is the need for access, right? We want community members to feel like they have access into the city, and you know, the Police Oversight Commission has done an amazing job at having advocates for that reflect what the city looks like. And I think through a sanctuary city board, we can do that across other portions of the city and the work that the city does. So just, you know, to use as an example, the funds, right, that the city council put together, and the connection and the need for connection with the community members that we serve through different organizations and different advocates. So I think access is the biggest thing that I think of when I think of the Sanctuary City Board.
Thank you, Ms. Acome. Yeah, totally appreciate those comments. I think in the context of the Sanctuary Advisory Board, a lot of the times it has come up in the context of the police department. And so I want to make sure that that stays within the realm of the Police Oversight Commission, because we do have jurisdiction under that. And I'm one of the, I think, only people here that had direct experience with immigration as someone that has lived that experience and helped write this policy. So I really appreciate that. That's all my comments.
And Commissioner Perea, if I could just respond briefly. So you all have a copy of the most recent red line that I provided. I believe it does, to a certain extent, address some of the recommendations from our presenters here tonight, not all of them, but I think that this current version is just a first step in an ongoing process. So happy to build on what I've created so far and add the recommendations that are not already in there moving forward.
Commissioner Syed, you have a question?
Some comments and questions.
Okay.
Thank you so much to our presenters, first and foremost. Thank you for gathering the data and putting it together for us. And one thing I'd like to say just to the city or city staff, a way to save money is by reducing the air conditioning in here. If we set it to 75, we wouldn't have a excessive bill anyway. So I do have a question about the referral. I don't know if our commander can answer the question, but what is the requirement to refer someone to a different jurisdiction for the U visa as opposed to processing it here?
Good afternoon. There is no necessarily a requirement. It's an option that oftentimes when cases, the victim brings up a case where they were a victim of a crime and there's an actual already prosecutional or a prosecution ongoing, that is why they get deferred to the DA's office, because that case is already in prosecution. And so they have a better understanding, you know, about, you know, they have direct contact or with the victim, you know, are they being helpful? Are they helping with the prosecution? And so for those reasons, they are deferred or sent to the DA's office, but there's no requirement specific.
Okay, so if just so I understand, if the person has an active case where they're involved in a criminal case, it can get referred to the DA, whether it's them or someone else, but they're part of that criminal case.
Correct.
I have another question. How come the data is difficult to get with the referrals? Because I can, and that was my question to our speakers, but I guess they answered it, is how come we don't have the data from 2017 to 2023 on the referrals?
I'll handle that one. Good evening. So there was a period of time where when we would refer U visa applications to other entities, that they considered that a denial within the Santa Ana Police Department. That's why it was stated that way. It wasn't until Chief Rodriguez started to take a closer look at this, and some of us on staff started to analyze it, and we thought that that was not an accurate reflection of the data, calling it a denial, because we weren't technically denying it. We just weren't the appropriate entity to be analyzing it. So that's why we created that third classification moving forward for statistical purposes.
Okay, so just so I understand the data, from 2017, there was a lot more of the denials, so 280 versus 150 approvals. The 280 encompasses the referrals.
Correct.
And then we see the change in 2024 where we started to track referrals, not categorizing them as denials.
Correct. It was an attempt to get a more accurate reflection of what was exactly transpiring with these applications.
Okay.
But the majority of the referrals are denied by the DA's office. I mean, that's not reflected there, but that is true.
Okay, I don't have that data in front of me to comment, but
And nor do we at the police department.
okay. And that goes actually to another question. Once it's referred to the DAs under the legislation, we don't have a duty to follow up and see the result of that individual's U visa, correct?
That's correct.
How many police officers and/or staff are currently involved in processing U visas? How does that work in the police department?
So we have a unit that oversees the process of the U visas. To my understanding, there's at least one professional staff member that inputs all the incoming information, or when they receive the applications. We have a sergeant that reviews each of the cases and then assigns them to possibly, I believe, 3 to 4 different detectives to expedite those cases and review them.
Have they received training relevant to making determinations on processing applications?
I'm not sure.
Okay. Can someone from that department start tracking? Because I know that a report is really important to this commission regarding the data. Do you have an analyst in that department or someone who can just track application submitted, referred, denied, whatever the consequence may be?
Yes, so in fact, the professional staff member that inputs the incoming applications is our crime analyst.
Okay. I do like the idea of the appellate review being a different person from the person who's initially processed the application, because in court, when you go to an appellate court, it's a different body that you can present evidence to. How does that work currently with SAPD if someone appeals a denial?
So typically that will come in the form, so if there's a denial that takes place, typically that'll come in the form of somebody just contacting them, requesting the nature of their denial. And then obviously there's times where they escalate that to the division commander and the bureau deputy chief. And sometimes those appeals I guess you can say those arguments make their way all the way to the chief's office. And then there's a discussion that transpires around that information, and ultimately a determination is made if we may have failed to consider some information.
Okay, so I do like the idea of someone else being able to review the evidence that's sort of new, so like a de novo review, just to make sure that someone initially didn't make a mistake. So I would like that recommendation as well.
Well, and just for clarification. The incoming U visas, they get cataloged and then they ultimately get reviewed by a sergeant, they get assigned. Then once they get assigned to that detective, they'll review it, they'll make their assessment. The first step of review and analysis is with our frontline supervisors, and that's our sergeant. If they agree, disagree with the detective, of course, they can have a conversation and make a determination there. If needed, of course, it can go to the commander and so on and so forth, like I said.
I had a follow-up question to that. Oh, if an appeal is made, how quickly, if someone can remind me, is the time in which you have to respond? I don't know if someone has that offhand.
I believe it was 7 days within our policy.
Okay, so if someone finds that the denial should be reversed, it would be within the time period allocated under the laws, correct?
I think there's a different time period that exists if they're in removal proceedings. Without having it right in front of me, I couldn't tell you that exact.
Okay. There is a couple more questions I had. Oh, I also agree with the accessibility. I mean, I'm an immigrant. My first language is not English, so I can understand the barriers in terms of having applications or processes online that are in different languages and all in one spot. I think I've voiced this before. Just generally, the city's website is not that user-friendly, and I have the app. And even then, when I'm trying to report something, it takes me through 10 different screens, and I just want to hit submit. And then it's like, you can submit anonymously, and it's too complicated. So if we could have just a really nice page on perhaps SAPD's website of everything in different languages. I know that's not a big ask, but I think it would definitely help for those folks who don't necessarily speak English as their first language. Couple more things. Yeah, we shouldn't, I don't know, again, enough about the facts of the community example, but if we are going to refer someone to the DA, it should be the correct contact information, because I know I've seen trends with government generally is you get the runaround, and when people are being deported very quickly, we don't want to do that. We just want to give them the correct information so they can do what they need to. I do have a concern though. So it sounds like in one camp, we don't want any discretion for the police department, and then in another camp, we want a ton of discretion regarding the word helpfulness. And I think there's contention with the two. So we've got to articulate or find some sort of way where we're being consistent about discretion. So do we want to eliminate discretion, or do we want to give them equal amount of discretion in deciding the facts and determining what helpfulness is? And with that, I'm done. Thank you.
Any other questions, comments, concerns?
I didn't know we were able to make the recommendations, so can I add my recommendations? I can.
Let Castillo on. Go ahead. Go ahead. He's yielding the floor to you, so go ahead.
Sure. So I actually did have one more question to you all and comment, and then I'll do my recommendations. It seems to me, based on all the presentations we've had, that there's a difference between, and one of the core issues is that it seems, at least to me, that Santa Ana PD's interpretation of helpfulness is kind of usefulness, and helpfulness and usefulness is not the same thing, right? Helpfulness is cooperation. Usefulness is to this will be, useful to you all to make the determination in cases, which is not what the law is saying. To that, also on the comment about the DA referring is not part of the legislation. The legislation there's no policy or legislation that says Santa Ana PD has to, right? There's no requirement. That's a choice you are all doing. And I can understand if you're getting a lot of cases where you might send them off because, as you mentioned earlier, you think that they might be better judgments of the case. However, again, the word helpfulness is even part of the investigation, right? And I think that's why you guys, not you, but in general, the PD's culture of understanding this seems to be usefulness. So I think that needs to be clear. That's kind of the core issue. In terms of the, I do want to thank Director Morris for the draft. I do think this is a good first draft. I don't think this is a final one, but I do think it's a good first draft. I was wondering for the 4130.3 on number 1, you have been the victim of a qualifying criminal activity, and then you have separately the direct and indirect victims. I understand why they're different, right? Because there's different qualifications, but I was wondering if you thought it would be useful or suggest that we add the bystanders also as part of the beginning. And I say that because sometimes when folks are reading this, especially if there's a gap in training, they can easily dismiss someone and not read to the second component. And I think that having who qualifies at the first sentence at least can be helpful or useful.
Sorry, add that where?
So on the first one, 4130.3, the U visa eligibility and legal requirements. On number 1, have been the victim of a qualifying criminal activity that occurred in the United States or violated. So on the second portion, you include the direct and indirect victims, which I think that's great. But I was wondering on number 1, where it says have been the victim, I'm suggesting that maybe we can also incorporate have been the victim or bystander or indirect in there, because if someone's looking at the policy and they're briefly looking and saying, oh, you're not a victim, and dismiss the rest, I just want to make sure that they're not overseeing that. Unless there was an intention as to why you did that.
Well, so the language in 4130.3, numbers 1 through 5 there, that language comes from the applicable statute. I hope that someone is not just reading the first or second page and saying, well, that's all I need to know.
I hope so too.
Right. So I think it's impractical to try to squeeze everything into, the first 1 or 2 pages, which is why this is now 8 pages long. I think that additional information that really gets into the weeds is necessary and should be taken as a whole. And if someone is just looking at, the first couple of paragraphs and stopping, that's a mistake.
Yeah, I agree.
Yeah.
I still believe that happens.
Mm-hmm.
I'm not suggesting for you to switch the direct and indirect completely there. All my suggestion was to comma bystander. That's all. The other thing that I would suggest, and obviously we're all going to vote on it later, is on the following page on 4130.33, where it says victim's responsibility to be helpfulness. I would recommend or suggest if we can move away from that language, because I think that it speaks to what has been the core issue again about helpfulness, and rather maybe guidance to helpfulness, definitions of helpfulness might be more appropriate. I do appreciate adopting the definition that was recommended from our previous presenters as well as today. So I do think that this is in the right direction to get clarity. And on the...
Sorry, would you repeat what section you're in?
Yes, 4130.33.
Mm-hmm.
Victim's responsibility to be helpful.
Right.
I was just suggesting, rather than the title being victim's responsibility to be helpful, for the title to instead maybe be guidance on helpfulness, definitions of helpfulness. And the reason for that is because we know that when people are having discretion or making decisions, especially frontline staff, responsibility to be helpful seems to be, again, responsibility on the individual of them showing proof. And we know, one, that the law does not state that, nor does the law does not state that, but the practice clearly in Santa Ana PD does. And so having victims' responsibility to be helpful, to me, further suggests that it is a responsibility rather than a default.
Understood.
On 4130.4, I'm curious the law enforcement role in U visa certification. So we continue to have the same conversation, right? About the role of Santa Ana PD in certifying. I think it's been clear through presentations from both legal and other communities, organizations, that the role of the U visa based on the law, the role of Santa Ana PD based on the law is to certify, right? Not adjudicate, not determine law, which was clearly stated also at the beginning of this. And so I wonder if, whereas the first paragraph where it says, such as a department verifying the applicant is the victim of the qualifying criminal activity and has been helpful, because is being helpful or likely to be helpful, do we really need to insert that there, given that we already provided guidance on helpfulness before, and that we're giving guidance to presume that they're helpful unless otherwise proven not to?
You're recommending that we delete some language regarding helpfulness there?
Yeah, it just seems redundant if we already established that the default is going to be helpful unless proving otherwise. So obviously there's still the guidance of if someone is not being helpful, that they are obviously not, but that the default is.
Okay.
I mean, we want to make space, right? I think that's one way to do that. And then I do want to push back a little bit on the for use of the section 4130.5 on the procedures for U visa certification. Again, it doesn't seem to be a legislation decision to forward cases to the DA's office. It seems to be a local decision. I also wonder if once we address and have better guidance about helpfulness, that maybe the officers have more opportunities to go through the cases a little bit more quicker, that may not need for them to defer them to the DA's office. I don't think I'm so clear that that's, my understanding is that it's not a policy nor legislation, but rather a decision that Santa Ana PD has taken as a practice.
I think something to consider, and I think something that the policy can be more clear on is factors for CID to consider before forwarding applicants to the DA's office. But Form I-918 Supplement B requires that the certifier check certain boxes, right? And number 3 is, since the initiation of the cooperation, has the victim refused or failed to provide assistance reasonably requested in the investigation or prosecution of the criminal activity detailed above. If the DA's office has taken over prosecution of that case, the DA's office may be in the best position to answer that question, and the police department simply may not know.
And is that, I think that is the question that we were trying to answer last time too in the last presentation, right? That the and and the or, that is not necessary, right? Because even when we had the 2 attorneys do the presentation, it was my understanding that it doesn't need to go to the DA's office. I understand that maybe it makes some sense given that they're in the prosecution, but it's not necessary. But yeah, I agree. Maybe some guidance as to what requires that.
Can I ask a quick question to piggyback on that?
Yeah.
If the complaint, if the victim is making a complaint against Santa Ana PD, what happens in that case? Because the agency who's approving the application is also the agency who's being accused of a crime, right? In that instance, would it go to the DA's office automatically?
Your question is, if a resident is applying for U visa, but yet they have a complaint against the Santa Ana Police Department?
So they were a victim of a crime, or they're claiming they were a victim of a crime that involved Santa Ana PD. And so they don't have legal status, they want to apply for a U visa. In that instance, would the agency who's going to go through the application with that victim be the DA's office, or would that still be Santa Ana PD?
So in your scenario, who's the suspect in the crime?
Sorry, if I could just clarify, I think what he's asking if the perpetrator of the crime is the Santa Ana Police Department, what happens then?
Yeah.
So then the best person would be the investigative entity whoever's investigating the conduct of, in this case, would be the Santa Ana Police Department, would be probably best suited to do the certifying of that particular application, whether that's the FBI, whether that's the DA's office, whatever entity would be investigating that conduct.
Okay.
Can I piggyback on that one that you just?
And I asked that because I was thinking about the case that you brought up last time and what process happens then.
Yes, that opens another kind of like question for me. If, and this is all dependent on what the city council ultimately decides on the scope of this commission, will the Santa Ana Police Oversight Commission be considering in that case, if we retain investigatory powers, like a proper entity to do that? Let's say the oversight director, if the victim is collaborating with the oversight director.
So what's the question?
The question is, if in the case where if the SAPD officer is a perpetrator, and we have an investigation going on with the Police Oversight Commission that requires the cooperation of the victim, will in that case, will Santa Ana Police Officer, the Police Oversight Commission, be an appropriate entity to certify the UVisa process? I'm just asking.
The U-Visa has to be certified by the police department, by the
police
chief
department.
of police.
Okay, thank you.
Sorry, Commissioner Mejia.
Robbing me of my time. Just kidding. I'm done.
For now.
Castillo?
Sure. I just have a few comments. I just want to thank our speakers, Ms. Leanda and Ms. Jacome, for their presentation. I thought it was really helpful, and I want to thank my fellow commissioners for their recommendations. I think we have a lot of really good recommendations. I do just want to highlight, as the Oversight Director mentioned, we are going to be discussing revisions to the ordinance, to the policy that's currently in place. And I think that policy or those revisions will go a long way to address some of the recommendations that were made today. So for example, the red lines to the policy, dictate written explanations for why a U visa was denied, includes language about, assessing helpfulness from the victim's point of view. It includes language about an appeals process, including that the appeal will be handled by somebody that was not the original certifier or the evaluator. It also has language dictating that there's a presumption of helpfulness, and it has a whole set of factors or examples that the person who is in charge of, or making the determination of helpfulness or certifying a U visa application can look to in making that determination. So I just want to point that out because we're making progress definitely towards implementing some of these recommendations. The other thing that I want to say is that I do think obviously there are issues with the way that these determinations are currently handled. I don't know if it's ill will necessarily by the police department in that they don't want to certify petitions or applications for U visas. I think a lot of this probably stems from, my opinion, a lack of training. So when I see 280 U visa applications that were denied, to me that just indicates that the people who are making these determinations just aren't informed of the relevant legal framework. And while I think it's great that we are making recommendations to the policy that's currently in place, and they're very robust from what I've seen, I think it's important that we couple these recommendations or these revisions with also very robust training so that the people who are making these decisions are kind of up to speed on the policy and they understand the framework that they're supposed to apply. Thank you.
Any other questions over here? I have a couple of questions, and again, I want to thank our presenters for their dedication. If nothing else, I have to admire you for that. just for my edification on this, to be clear, if somebody is detained or in custody, is that the end of the U visa process? Does that bring it to a halt? I don't know. It does not. Okay. And the other one too is also if it goes to the DA's office, is that the end of the U visa process? It is not. Okay, thank you. And I do have a comment on in concerning our policy here. It regards the time constraints. If they're not met by the department, what are the consequences? I know they're severe for the individual, but what are the consequences within the department? How do we ensure that these time constraints are met? Because again, as was pointed out, the consequences are severe for the individual. So that might be something we want to add in there to have some metric for meeting these time demands. Thank you.
Sure.
Any other comments, questions?
I do want to say thank you to both organizations for coming out and giving us some very good information and data, and there are a lot of great recommendations here. Me personally, I just really would like to know, more information behind these denied applications. And I have a clarifying question. So is it Santa Ana PD's role in this application process to really just determine the, I guess, quote unquote, helpfulness and not to assess the, whether they fall within a qualifying crime?
So simply, there's various levels of analysis. It starts with the qualifying crime. It starts with determining helpfulness. But both those criteria have to be met and part of the certification process.
Because I believe that one of the presenters said that wasn't up to you guys, if I'm not mistaken. I was wondering if that was true.
They have to certify that a crime occurred. That is the role. Like somebody cannot be lying or making up. So that is the role. But in terms of helpfulness, this is exactly one of the reasons why it's been challenging, right? Because there's this assumption that they need to be helpful and to what extent. But you're right, the attorneys did mention that helpfulness can be throughout either through this process of getting the investigation, through the prosecution process. So it can be in one of those. It doesn't have to be all. And I believe Sandra also explained that. So you are correct. And I think that is one of the reasons why I've been pushing about clarity on helpfulness, because it almost seems that Santa Ana PD, the department has been having high denials based on the definition of helpfulness. And I believe that people don't really understand why they were being denied either. So I think they also would like that answer.
So if I may, I believe I can answer your question. I believe what you're referencing is when the attorneys reference the rebuttal presumption of helpfulness, which basically by default means the default is the person is to be considered helpful unless expressed otherwise. And I think was in the context of if the police department just follow the rebuttal presumption of helpfulness, then nearly everything gets certified. I think that, if I remember correctly.
Assuming that the crime occurred, though, there's still a process.
There's
Not
still
everyone just gets clearly
There's still a
given.
qualifying crime that has to, we don't even get to step B in terms of helpfulness if there's not a qualifying crime.
Any other questions, comments?
No, none for me.
I have one more comment, and I promise to not make it super academic. So, and hopefully I can be clear on my goal. So I think, and I do appreciate Said's point earlier about that there seems to be different perspectives of what helpfulness means. And I just wanted to state that one of the reasons why, at least I can speak for myself, is that I do agree, I do like what is currently on the first version of the edits of the policy, is because when you have an organization, and any organization, it doesn't have to be Santa Ana PD, people making decisions, and especially when the culture is to prove evidence and prove otherwise, then that thought process is then seen, even with folks who are victims. And so my concern is when you have an agency whose culture and you're dealing with every day, right? Like, what is the evidence? How do you prove this? And now you're applying this into a policy that is quite a little bit different, but your role is still to certify. I do think this is where we see this dynamic happening. And by having this definition will be more useful for victims who are applying. Again, it doesn't mean that everyone who applies just gets a certification. There's still a process. They still have to qualify in the crime. They still have to be a victim or a witness of the crime. So not everyone that applies will get it. And also, if they show otherwise, that they were not being helpful, then obviously they don't get the certification. But I hope that clears up folks who have different perspectives of how this should be used in terms of discretion.
Okay. Well, at this point, we're going to ask our city attorney if he's captured the commission's direction. I believe that's where we're at.
That's for our oversight director to bring that information.
My apologies.
But I have.
I'm looking. It's always a little tough for you, I know.
And I have too.
Okay, thank you. Okay, and I guess we're at the point where the assistant city attorney summarizes commission's directions, but you've already said that you've got it down and we're all good to go. Would that be correct? So I guess that brings us to the conclusion of this study session. And we'll move on to the comments. Deputy City Manager, do you have any closing comments?
Yes, thank you, Commissioners. I just wanted to bring up that you should be receiving invitations to meetings with our city attorney, police chief, oversight director, and city manager in regards to the Police Oversight Commission ordinance amendments that are being proposed. So if you haven't already had your meeting, you'll have it with the council member and those individuals. So please look out for that.
All council members?
So it's not a Brown Act violation, and we don't want to do all council members. So it's a council member with his or her commissioner, and then with the city manager, the police chief, the city attorney, and the police oversight director.
Are we allowed to individually request to meet with certain council members? And it obviously it's up to them whether they would like to meet with us. Am I violating anything?
You would not be violating the Brown Act.
Thank you.
All righty.
Sorry.
Go ahead.
I didn't know we were supposed to make our recommendations to the ordinance, or I'm sorry, to the policy when we were discussing the training. So if I could just add a few comments to the red line. Is that okay? Okay, so my first comment is, so we have a section 4130.3 that talks about U visa eligibility and legal requirements. And it's quite long, and talks about, let's see, 4130.3.3 talks about the responsibility to be helpful. And then in that section, we provide examples about things that the department's supposed to consider in evaluating whether somebody has been helpful or not. I would recommend moving that discussion to section 4130.5 procedures. I just think it's a little out of place currently, because to me that section 4130.3 is really kind of like the legal framework, and the part in the policy that's talking about what the police department is supposed to do when they review each case refers back to that section. I just think it seems a little out of place. It would make more sense to have the factors that the police department is supposed to consider in evaluating helpfulness in section 4130.5. That's my first recommendation. The other thing that I want to point out is that there seems to be an inconsistency with regard to the Form I-918 Supplement B, and specifically what is supposed to happen in the event that there's a denial, or let's see, it says section 4130 .3.3 says that if the department determines the victim has unreasonably refused a reasonable request for assistance, the department may sign and certify Form I-918 Supplement B, noting the refusal and an explanation. But then later in the policy, it says that they shall do that. I wrote that down somewhere. 1 second. Oh, so if you go to 4130.5 procedures, and then it's number 8, says if the CID sergeant does not certify a Form I-918 Supplement B, they shall provide a written explanation. So I just think those two things seem inconsistent to me. I think it's probably just a typo, but I'm just pointing that out. And then the other thing is under section 4130.5 procedures, bullet point number 10, it says, this is talking about the appeal process. If a victim's U-Visa certification application has been denied, the victim or their representative may repeal the decision. I think that's supposed to say appeal, but correct me if I'm wrong.
Sorry about
that. All right, and I think those were all my comments. Thanks.
Okay, now it's time for final comments from our commissioners. And we're going to start on my right. Commissioner Goransky.
Hello. It doesn't have to do with our education that we got tonight, which was wonderful to listen to. What I want to ask is that I was asking one of our police from I didn't push the button. I'm so sorry. Don't tell anybody I used to teach school, will you? To whom do I ask or speak if you've already had the ride-along and the class, the citizens class, do you have to do it again? I had it quite a few years ago. I was in the very first citizens class. It was absolutely wonderful, and everybody should take it. It's a complete scenario that they give you at the beginning, and you have to solve the crime. It takes you about 13 weeks to solve the crime. We had SWAT helped us out. We wore guns, we shot guns, and anyway, it was a lot of fun. But like I say, it's a scenario at the very beginning, and you just run through the whole thing in 13 weeks. You have the felon, and he goes to court, and the judge comes, and et cetera. But what I wanted to ask, that's how wonderful it is if you haven't been to it ever. Do you have to do it again? That's my question. To whom do I ask?
We can check in on that.
Pardon me?
Our office will get back to you on that. We can check.
Oh, okay. I'm not complaining, I don't want to, but if, you waste somebody's time, that, whatever.
May I go back to Commissioner Castillo-Lawton's comment about the issue regarding may and shall. So in section 4130.3.3, where it says if the department determines the victim has unreasonably refused a reasonable request for assistance, the department may sign and certify Form I-918 Supplement B, noting the refusal and an explanation of the refusal. So that refers to the page on the form where the police chief has the 3 check boxes, and that's referencing number 3. So if the person has refused assistance, the chief can check no, but still sign it. That's certifying it. But in section 4130.5.8, that's addressing a situation where the form is not certified, so it's not signed. Then they shall provide to the applicant or their representative an explanation noting why the application was not certified at all.
Okay, so in 4130.3.3, the may language, that is in a situation where whoever's the certifier still certifies. So they can say that someone stopped being helpful but still certify? Is that right?
Yes, as I understand
Okay.
the process, and maybe the chief or commander can further clarify, but if you look at page 3 of 5 on the Form I-918 Supplement B, so there's those 3 questions.
Sorry, did we receive a copy of that?
No, it's not in your packet.
Okay,
Sorry about that.
that's okay.
At any rate, the question 3 is, since the initiation of the cooperation, has the victim refused or failed to provide assistance reasonably requested in the investigation or prosecution of the criminal activity detailed above? If the answer is no, it's my understanding that the chief can provide an explanation. There's a space where you can write more information regarding each of the questions asked. It's my understanding that the chief can mark no and then still sign it.
Sorry, do you mean yes? Or if?
No, I mean mark no.
No, they have not been helpful.
They have not been helpful.
Okay, got it. So maybe it would be helpful to clarify that in the red line, in the policy, to explain that it's in the context of a certification instead of a denial.
Okay.
Commissioner Vega.
I just want to say thank you to staff, our presenters, and everyone who came out to provide a public comment. And to staff, I wanted to know if it was possible to get information, maybe via email, regarding Santa Ana Police policies surrounding encounters with individuals suffering mental health. I believe this may have been touched on in one of our trainings a couple of years ago. But I want to refresh my memory, and also whether or not we have a policy when it comes to language when we're giving orders to individuals. Is there a policy in place that states, okay, we should probably speak to this individual both in English and Spanish? I don't know if we have a policy surrounding that, but if we do, can you provide that information to us? Or maybe answer that now.
We have no policy that says that we have to go through a series of languages. Sometimes we're limited. Some of our officers are only English speaking. However, I think through time and experience, they pick up both languages, at least in some of the more key commands, but there's no formal process there. Our policy, I should say.
And those are all my comments.
Commissioner Mejia.
Yeah, I just want to thank everyone, staff and presenters, and as well as all my colleagues. I think that we had a productive conversation on U-Visa, and I think we're moving forward in the right direction. Hopefully we can finalize this and have this applied to be helpful sooner than later. I do have a couple comments / questions for Commander. It is my understanding, and I wasn't there, so this was just information from a community member given to me, and relaying the message with questions. So it is my understanding that there was a meeting yesterday, I think. Sorry, it's been a long week, regarding the military equipment on AB 481. And there was low attendance, and obviously I know that sometimes that is not always, PD's fault, but I do wonder how we can improve letting the community know that these meetings are happening in open forum. Accessibility of time, I believe the meeting occurred at 4 p.m. And I wonder if it could be a little bit later for folks who work up until 5, maybe possibly 6, 7 p.m. meeting. And I think the two comments that I was informed that it was a little bit concerning, again, I wasn't there, so I'm just asking for clarification, was that the officers who were presenting mentioned that they dropped the ball, they failed to report adequate information on the report, and given that this is a mandatory legislation to report on, I was just curious as if there's going to be a follow-up meeting for more accurate information on this.
Thank you. I can take that question.
Oh, are you?
I'll just answer. Okay. So for 22-23 and 23-24, the reports were prepared, but they weren't posted, and you're correct. We were out of compliance because there wasn't that community meeting that was held. So
Can you clarify who's we? Is it
the city of Santa Ana.
The city or city manager's
The
office?
city of Santa Ana.
In general?
Yes. Yes. So they were not prepared, correct. So now what we're doing is we're looking at our ordinance, and now that we have Chief Rodriguez on board, he's making sure that we're complying with all the laws, regulations. So instead of just bringing this year's with the community meeting, we presented all three so that they could all come to a body as required by law. And in addition, reaffirming the opportunity to reaffirm our current ordinance.
Thank you. One more follow-up. It is my understanding that even what was reported was quite light in information. Is there, I think my question is there going to be more thorough report, current report? I'm not talking about previous report from 22, 23, but just like the most recent.
The reports that we're presenting are the current reports that we have for those 3 years that were identified.
Okay. Those are all my comments.
Commissioner Syed.
Thank you so much to everyone who spoke today and to our staff who's done a fantastic job. And I had a couple of thoughts based on the speakers I heard earlier in public comment. Now that we have a director, I would like to see if we can start watching body-worn camera or the critical incident video in closed session regarding the shooting that was brought up earlier today. So I'm not sure how to start with that.
We do currently have the critical incident video posted on our website.
Okay.
And
But the body-worn camera, which is probably longer
the raw
than...
footage.
Yeah, is that available for us to view or not yet? If it is available, I would like perhaps a closed session so we could just watch it and determine facts for ourselves.
So we'll take that under consideration. Obviously, we need to have a conversation regarding potentially Penal Code 832.7 and issues surrounding that. I don't foresee any, but it's just simply a conversation, and we'll figure out a way to address that and make sure that we address it in the proper format.
Excellent,
Sorry, Jonathan,
thank you.
can you just explain what 832.7 is?
It's confidential peace officer records, and it very much may not even apply in this case if it is a qualifying incident. But again, we want to fully evaluate that.
I have a question on that. Is this incident something that our director is currently tasked with?
Not yet.
How, just to get clarity on how this is going to happen, now that we do have a director, do we need to recommend that this be looked into, or is this going to just occur at your discretion?
And I believe you currently have subpoena power under the current ordinance.
That's not my concern. I'm just concerned about the process.
Well, I'm only making that point because I think we can direct the oversight director to take action, and he can subpoena records under the ordinance as it currently stands.
Understood, but again, the process, I mean, do we have to recommend that, or is this going to take place? Or, because our holdup before was because we didn't have a director. Now that we have a director, do you take the ball and run with it, or do you need direction from us to take the ball and run with it?
Well, something to consider, as you all know, is that the police department, I assume, is in the process of conducting their own administrative investigation. So as part of their investigatory process, they will interview the involved officers and make their own conclusions. So I don't know if the commission is considering tasking me with conducting a separate parallel investigation or and making findings that may be in conflict with the police department's own investigation, or something that's more geared toward looking at tactics and protocols and what the department may consider moving forward, making general recommendations about what the involved officers did and did not consider, did and did not do. So not really a full administrative investigation, but I could look at the investigation that the police department conducts, make comments on that investigation and tactics and protocols for the police department to consider moving forward.
I don't know, but my thought was if we could see the BWC, I think we'd have a better sense of how to direct.
Yes, I agree. And what I would say is that I think what I would ask for is that, Mr. Oversight Director, that you work in conjunction with the Santa Ana Police Department on this investigation and maybe report back to us what the findings are or what the findings are coming out to be, maybe in a closed session, but at least, you know, we can let the public know that we've taken an interest in this and that we're making progress in investigating.
I would second that because, again, the whole point of this commission is to bring things forward for the public. And it's been quite some time, and I think to Castillo-Lawton's point that would be a very good thing, that we can actually show that we're moving forward.
And just if I can intervene briefly, I just want to remind the commission gently that we were in closing comments at this time and we're kind of bordering a bit on like a business calendar and again, issuing direction, which this is not the proper venue or time. But to the extent the commission wants to express their concerns and comments and put that out into the universe, this would be the time to do so.
Thank you.
I would like to put that out in the universe.
My closing comment is just that if we can get the facts, then we can see what's going on, and that would be helpful in direction and decision making and policy making. And with that, I have no other comments. Thank you.
Sure.
I mean, everyone else spoke and no one said anything. So I just wanted to add that I think that I agree that we should look into it, but I do respectfully disagree that it should be in conjunction. I do think it should be independent and separate because I do think that in order for us to get there eventually, we first need to gain the public trust that the city doesn't have. And so I think that one way doing that is by first being independent and then moving forward. But I do think it would be helpful. I think for me specifically, I'm unclear of if we can start looking at investigations. Like, can we? I'm not saying right now to vote on that, but after your comment, I understood that as for the next meeting or even to set something on the agenda, we could, moving forward, start directing to start looking at cases. Is that correct?
The ordinance as it exists right now contemplates that the oversight director can conduct investigations.
Okay, so then yes, thank you.
Commissioner Pereira.
First, I am very excited about the work that we got done today and over the last 3 sessions really on the U visa policy. I think this will be the first policy that we actually as a commission have got into and truly ensure that it is revised and responsive to the needs of the community. So I think that this is what we were meant to do as one of our functions of the commission is to actually do that. And I look forward to doing that with different major policies that the police department has, where we have the presentation from the police department and we bring in community and legal experts to also provide us with their feedback. This is the best way how we can get things done here. So I really want to commend the city staff and everyone involved and as well their community organizations that have come to present. My closing comment, so I am interested, Director Morse, I will work with you. I have a recommendation for an agenda to be added, and I will send a formal request to you regarding reviewing the response from the Santa Ana Police Department to the public demonstrations that took place earlier in the summer. I agree with one of the speakers, public speakers that came here today, that it is our role and the job of this commission to review those incidents, to provide clarity to the community. So I'll be sending that formal request to agendize that item. I do want to remind commissioners, right, that we can provide things into the universe from our closing session, but we can also email directly Director Morse. I guess we also saw our bylaws to be able to agendize items. I think we should make best use of that as well. And the closing comment, so I do want the commission to move forward with conducting our own investigations. I do, however, want to remind the commission that a lot of that will depend on how the council ultimately decides where to land in this ordinance. I hope that everyone took a chance to look at the discussion at the previous council meeting and to see where your own council member stands on the revisions of the ordinance. As it stands, it will strip the commission from conducting investigations like the ones that we are making comments today about. And so I believe that there's different models that can be looked at, but ultimately, again, what the scope of this commission, it will depend on that joint session that we will be having. So please take a look at that video, see where your council member stands on the revisions. And I look forward to the hopefully productive conversation that we will have with them at our joint session. And those are all my comments. Thank you.
Thank you. Again, I'd like to thank our presenters for their dedication and to our staff and our new director for his work on this. Yeah, I'm concerned about the term helpfulness getting thrown around the way it is. It is getting to be kind of a nebulous term. I think it's going to be hard to nail down. Hopefully we can come up with something that's not too restrictive, but does allow some discretion. But again, thank you. I think that's pretty much it for me. And thank everybody for all their comments. I think it was very good. And
one last comment, if I may. I'd like to thank you very much for turning that air down. Is it a big difference down there? Much better. Thank you.
Okay, with that, the next Police Oversight Commission meeting is scheduled for Thursday, September 11, 2025, in the council chamber at 5 p.m. I hereby adjourn the meeting at 7:32 p.m.